Hello and welcome to episode 17 of Estate Planning Weekly. Today I'm discussing why having joint bank accounts and pay on death designations on bank accounts does not equal an estate plan. This is episode 17 again, and I am your host, Don Rolfe, the owner and founder of Northwest Legal Planning, an estate planning and probate law firm located in West Linn, Oregon, and serving the greater Portland metro area. So, you've heard that you can do away with having a will or a trust as part of your estate plan and just have everything held jointly, or use PODs, or also known as pay on death designations for your accounts, joint holding of real estate with right of survivorship, having a friend or family member as a joint owner of your bank accounts, and when you pass away, everything will just pass to the joint owner or the pay on death beneficiary, and they'll take care of splitting all of those things amongst the people that you've told them you would like to get your assets after you're gone, who you would like to have inherit. Well, there are a number of issues with attempting to do an estate plan this way. And the first issue I'd like to bring up is that if all of your assets pass by operation of law, which a joint ownership with right of survivorship or a pay on death designation does, it's triggered by your death. By operation of law, those assets transfer immediately. If all of those assets are transferred from you to other individuals by operation of law, then there's not going to be anything left in your estate to pay your final expenses. So if there are any medical bills that need to be paid as final expenses, your funeral arrangements, cremation, burial, all of those sorts of things, there will not be anything left in the estate. Also, your estate is going to have to file your final tax return for the year that you passed away. If there is a bill due, there's not going to be any assets in order to satisfy that. Which brings us to the second reason that they're not good, is that creditors want to get paid. So if you pass away and all of your assets get immediately dispersed to other individuals, creditors are going to come looking to those other individuals for payment. It might take them extra time, might take some court processes to get judgments and show that perhaps those transfers were fraudulent, that those other people didn't actually have an ownership interest in them, and the creditors will attempt to claw back those assets in order to get paid, where they would have gotten paid during the administration of your estate, either during trust administration or probating of your will. The other issue that comes up is that a lot of people think that, hey, I've got 3 bank accounts and a house, and I'm going to put Joe, my best friend, or Joe, my son, as the joint owner on those accounts, and then Joe will just take care of making sure that everyone else in my family gets their fair share, that, you've talked to Joe and Joe's agreed. Well, what can happen is perhaps Joe doesn't agree. He decides that he wants to go ahead and just keep those bank accounts because he was an owner of them, and when you passed away, he became the sole owner. Same thing with your real property, your house or vacation homes, or any other asset that you've put joint ownership name on, or if it's a pay on death, it gets paid out to one of your kids, and you've expressed that they're to share it with their brothers and sisters. So number one, they could decide that they just don't want to follow your wishes. But number two, that's putting quite a burden on that one individual, because if you have an estate that is more per person than the annual gift exclusion amount, the joint owner now is going to have to figure out a way to gift your assets that they received to the people that you want to have those dispersed to without going over the annual exclusion amount. So if each person is, say, to get $50,000, Joe now has the problem where he can't give someone $50,000 in a year without triggering some sort of gift tax. So Joe now has to either do it over a number of years, or he will have to hire a CPA to figure out what the taxes are going to be, reduce the amount distributed to those individuals so that he will have reserves to pay his gift taxes at the end of the year, which is not a good situation for Joe. It's actually quite a burden for him. So that's a third reason. And the final reason is that if you start adding people to your assets now as joint owners, that could trigger a present gift. And in doing so, it could run you afoul of some tax laws if you're not properly documenting those. So if you have a home, for instance, and you want to put your child on there as joint owners with right of survivorship, so they will have the home when you pass away, they are, at that time that you put them on the deed, they become an owner, and it's as if you have gifted, because they're not paying you any consideration for being put on the title, you have gifted them that half value of the home. So if it's a $100,000 home, you have gifted them $50,000 and right on up. So it could cause problems for you tax-wise right now if you're not doing it and keeping an eye, in a way to keep an eye on those things and getting advice from a professional that understands the tax implications of giving gifts. And then finally, if you give present day gifts, such as we just talked about with joint ownership with right of survivorship for a home with your child, you're doing that child a disservice because they're not going to get the full step up in basis that they would get when you pass away. I understand a lot of these things are coming back to tax issues, but our tax code is voluminous and very complicated, and it can get you if you're not doing things appropriately. So if you left a home to your child through a trust or a will, and you had purchased it for $100,000 and now it's worth $500,000, when you pass away and they inherit that home, they're going to get a full step up in basis. So their tax basis for the value of that home is going to be the date of death value, that $500,000, rather than the $100,000 when you bought it. However, if you gift it to them during your lifetime, that basis for the part that you've gifted to them stays at that lower $100,000 level, so that later when they go to sell that home after you're gone, there's going to be some issues with perhaps capital gains tax that there shouldn't be. And I used a home in this example, but it could really be any asset that can have a increase in value over time. If you have any questions about pay on death or joint accounts as it relates to estate planning, I'd be happy to answer them. You can give me a call at 503-850-8345, or you can go to my website and schedule a complimentary 30-minute consultation, either in person or by phone, and I'm happy to answer any questions that you have about this topic or any other estate planning topic. If you enjoy this video, please share it, hit the like button, leave a comment. If you know someone who might find this information valuable, please share it with them. Until next week, thank you. Goodbye.